that this is the stage that this honorable court must ensure, because it is the court, that all aspects and proceedings are dealt with in a manner that we all had, and I'm happy for the time that the court has agreed to allocate us, so that the court with sober minds can be able to decide, have the laws of our countries been upheld or not. My Lord, there are clear guidelines that have been set out by our constitutions for purposes of doing that. And my Lord, because we are here because of an application for conservatory orders, under Article 159 of the Constitutions, this court has an express duty that in exercising the delegated judicial power of the people of Kenya, it is required, the certain guidelines have been given by the Constitution under Article 159, that is besides other provisions of the Constitutions. And one of the most important one is that, that the court will do substantive justice. Substantive justice is an important issue, and it has specific meaning through the very many decisions that have been rendered over time by the courts of this country. And the clear meaning in plain English, because it is important we understood in plain English. In plain English, it means a very simple things. That, for example, my lords, if we have a case of a goat, Mr. X and Mr. Y have a case of a goat, this goat should remain alive, and so that at the end of the decision, the court can decide whether it belongs to Mr. X or Mr. Y. That is a very simple meaning of substantive justice. So that, my Lord, substantive justice, therefore, conservatory orders, is a mechanism that our laws preserves the goat. Our laws preserves the subject matter of the case. The subject matter of the case, my Lord, is the questions of vacancy in the office of the president. Going by the Senate, the deputy president was impeached. On account of the orders that have been given, that office is yet to be filled. So that, my Lord, the question, therefore, is easy to define and can be defined this way. That, as we wait for the hearing and determinations of this case, it cannot be settled at the interim level that the Honorable Kindiki will now be the Deputy President of Kenya, so that as we argue the petitions, there is already the impeachment process has been concluded to the disadvantage of the other people, of the other person who is seeking the same office. So that, my Lord, is a simple issue that is very easy to define. So that, my Lord, we shall be arguing that when we come to that particular issue, why on earth, because you have before you, because if a conservatory order is the legal mechanism, the legal device that is established by the constitutions to preserve the substratum of the matter and for this court to do substantive justice, how on earth does the respondents expect that substantive justice will be possible if the trophy that is being tussled over, that is being contested over, is handed over to them? My Lord, all systems of justice would be offended to be told that it is possible at halftime for one team to be declared to be the winner before the matches is concluded. Why can't we wait for all these issues to be concluded? It is a simple meaning of what substantive justice is all about, and the courts, the duties of the court to ensure that the ring is held even for all the parties, so that we do not argue over an academic matter, which would be the worst issues that can happen. My Lord, there is the case of the Gatirao Peter Munya. I'm coming to the applications for conservatory order. The principles are very clear. I just need to go on them as quickly as I'm able to. Under Gatirao Munya and other decisions, we have a big authorities, many authorities. The issues were set out very, very clearly. And there are three tests. The first test is on the prima facie case. My Lord, my learned colleagues have set out the various many legal issues that are there. That from the standpoint of the applications that we are arguing before you, there are 5 issues for purposes of the prima facie case to comply with the Gatirau Munya case. The first one, my lord, is public participation. I don't need to go into that. It's a substantive issue in the majority of that issue. My lord, the second issue is what we call the legality of the standing orders of the Senate. My lord, in the petition filed in Kerugoya as 015, the petitioners, amongst other things, are saying that although the Constitution provided for clear timelines on how, for example, the business is going to be conducted, and specifically said that this investigative committee is the only committee that can be able to discharge that constitutional function, the Senate established standing orders under which the plenary of the Senate can also resolve that issue. The Constitution of Kenya does not provide for a mechanism on how the Senate can discharge that function. But it is very clear on how that investigating committee is supposed to conduct its business and how the right to hearing is to be given after a finding has been made that there is a case worth responding to. My lord, I submit that's a big issue on the standing orders that were used to pass the vote of impeachment. The second issue that has been sought in that case is the issue of interpretation and application of those laws on impeachment, 44, all those laws, 48, 144, 144, 149, all those have been raised. My lord, as you clearly knows, this is a first impeachment for purposes of those laws. And therefore, if a question of interpretation has been raised specifically before you, it underscores the necessity to ensure that on merits, this court actually determines and interprets the law, so that the next time we have probably to do it against the president or against Kindiki if he gets there, the law would be clear and we shall not be going through all these things. So a serious issue has been raised by that petition. The other serious issues that have been raised is, of course, the fairness of the Senate proceedings. I will not go into that because already the lawyers for the deputy presidents have raised that issue. And the fifth important issue is the issues of nominations of the Honorable Kindiki. There are issues of the nominations. My learned colleagues will say more about that. But as we wait for their turn to come, the only 2 issues that I need to say at this early stage is to point out the fact that under the constitutions, I believe Article 137 of the constitutions, any person occupying the office of the deputy president or the office of the president must be qualified in accordance with the constitutions of Kenya. Under the impeachment articles of the constitutions, these issues of the constitutions on the qualifications are not set out. So that because they are not set out, it is an assumption that when reading the constitution holistically, this court will go to those other specific provisions of the constitutions where the issues of qualifications are set out. My lords, those issues of qualifications are many. One, and the body under the constitution, my learned colleague Mr. Ndego will say more about it, is that the IEBC confirms whether any person has those qualifications or not. I don't think that is a contested issue. I believe it is also not a contested issue that at the time that the President of Kenya appears to have received some letter from IEBC confirming that the Honorable Kindiki is duly qualified to hold the positions of Deputy President, courtesy of Article 149 of the Constitution, we did not have IEBC. Of course, various arguments can be taken by the parties that are before you. those arguments cannot be concluded. Those arguments can only be arguments to justify whether or not the conservative orders will remain in place or not. But they'll have to be settled when the petition has been heard. The second important issue on the aspect of the nomination of Kindiki that I need to point out is this, that even assuming the president did the right thing and everything else that he was doing, this court should be concerned by the fact that whilst the case was still going on before the Senate, the National Assembly scheduled a meeting by the National Assembly, which under Article 149 has 60 days, a meeting to occur the following day, within about 7 hours after the vote of the Senate. Why should this concern the court? It should concern the court for the simple reason that under Articles 10 and 118 of the Constitutions, Parliament cannot pass a law or make important decisions like approval of the Honorable Kindiki without engaging in public participation. The cases are so many for me to cite them. The jurisprudence is so clear for it to be disputed. So that, my Lord, the argument that we shall be putting on the issue of the nomination, unless this Honorable Court, that at this stage, that public participation does not apply to the nomination and approval by Parliament, then, my Lord, it is clear that this is the kind of case in which you are duty-bound to confirm the conservatory orders until this petition is heard and determined. Because the precondition would have to say, we have excluded this process from public participation. You would have to resolve the main issue, one of the main issues, at this stage before the petition has been heard. That would obviously be irregular. Now, none of us expect it to happen. I still wonder how the respondents would expect for them to get such kind of an order. I go to the second test, and this is the test of whether those orders will be rendered nugatory. My Lord, again, I will not use the word no-brainer, but my Lord, this is not a difficult argument to be able to resolve. I had a little bit say something about it, but my Lord, the whole argument would be this, that if the whole argument, and that has been our case since we first came here last Tuesday, that we cannot, my Lord, be able to have a situation in which the petitioners are saying the constitutions of Kenya has been systematically violated, and that all these obsessions with the application to set aside the conservatory orders that are in place are meant to complete the violations of the constitutions. My Lord, under the constitutions, your first duty is to defend the constitution. That duty is particularly greater for the simple reason, it's called Meduse. The MP, Metuse, that one. When the mover of the motion had that duty under the constitutions, President of Kenya had that duty when conducting, making appointment under 149. National Assembly had that duty, and the Senate. But my Lord, you are saying, it says, the constitution has been, my Lord, the constitution has been violated. And the duty that we do not turn this constitution into a hollow document is all the more greater. Park or whichever other press for them to say we are swearing Kindiki. That would be a mockery of justice. But there is a greater mockery of justice that I would want to point out. Because this thing, and to break it down for the people, every order in the normal litigations we do with every day, and you say somebody's rights are going to be violated. If somebody is saying I should not be hanged, I was not convicted properly by the High Court, if, my lord, that person is hanged before he has been heard by the Court of Appeal, clearly it would mean that the process of justice had not been completed, yet we have hanged the guy. My lord, in America, they keep on hanging people. Many of them terrible criminals, mass killers. But my lord, you will observe that at the time when we see these televised killings in America, it is always after they have exhausted judicial process, so that they are sure that process that are irreversible take place after legal benefit and protection has been accorded. One of those that is important, my lord, is captured under Article 27 of the Constitution, the right to protection of law. So that the issue, as long as I'm in court, the matter is not yet over. It might well be possible that we might lose this application, the interim application that is before the court. But we might also win it, and we are likely to win it. So that because, my lord, of that issue, that a person may actually succeed at the other stage is the reason why you prevent taking irreversible decisions. And, my lord, what is the scenario that we are talking here? My lord, with the scenario here we are talking about here is simple. Immediately after assuming the orders were lifted, that's the scenario I want to describe. What is it that is going to happen? My lord, we would have a scenario where the Chief Justice, whilst these proceedings are pending before the court, would have to preside over the swearing in of Honorable Kindiki.
To keep speculating about the swearing in of Professor Kindiki.
The issue of swearing in is
also, and he's referred to it 3 times now. This is the 4th time.
My lord, I believe that's the law. They have been saying they want to.
And my lord, whereas you are
then.
I was to ask my lord, what is the dispute before you? Is it the impeachment and whether it was lawful, or is it the nomination of the second interested party? Because
first of all, it's both, and I would want some protection for me to conclude so that we are all fair. They will have their time to respond, and I will not interfere with it. My lord, so that the important scenario that we must seek to avoid is a situation, and this is matter, it is also a matter both of the Constitution and statute law. My lord, the issue is that if we get ourselves into a situation in which the Honorable, the Chief Justice, might have to preside over the swearing in of Honorable Kindiki while this petition is pending, my lord, that, to borrow the words of Honorable, my friend Muigai, Senior Counsel, would be the greatest absurdity that we can encounter. Why is it an absurdity? It's an absurdity, my lord, for the simple reason, one authorities that we have cited is the assumption where, because of the experiences that this republic went through in the years 2007, 2008, specific laws had to be made to ensure that not only will this event be a public event. That's number one. But the more important issue from the standpoint of law is this, that before we get there, all legal disputes, contestations over the right to occupy that office would have been resolved. And my lord, that is the reason precisely why they say, after the Supreme Court has confirmed the validity of those 2 positions, then you do the swearing. My lord, it would amount to taking us back if that aspect, that rule of civilizations, were to be taken away on account of the setting aside of the conservatory orders that were issued, and for very good reasons, by your brother judges. I don't know whether there was a sister, by your brother judges. So that, my lord, the issue, as far as we are concerned, that is an absolutely important issue. we go to the next important issue, public interest. My Lord, public interest has been defined in very many cases that are before you. And my Lord, these public interest issues are just supposed to ensure that in administering justice, the court will do the right thing. Because we actually have a transformative Murugaro, Christopher Daradhi Murugaro versus Kenya Anti-Corruption. This I'm citing the passage appearing at page 7 to 8. My learned senior, Gedhu Muigai, will be familiar with this decision. My Lord, from the last paragraph, what did the Court of Appeal say on public interest? I read, it said as follows. Lastly, before we leave the matter, Professor Muigai we understood him to be saying that the Kenyan public is very impatient with the fact that cases involving corruption or economic crimes hardly go on in the courts because of applications like the one we are dealing with. Our short answer to Professor Muigai is this. We recognize and are all aware of the fact that the public has a legitimate interest in seeing that a crime of whatever nature is detected, prosecuted, and adequately punished. But in our view, the Constitution of the Republic is a reflection of the supreme public interest, and its provision must be upheld by the courts, sometimes even to the annoyance of the public. The only institution charged with the duty to interpret the Constitution of the Republic and to enforce those provisions is the High Court, and where it is permissible with an appeal. We have said before and we repeat it. The Kenyan nation has chosen the path of democracy. Our constitution itself talks of what is justifiable in a democratic society. Democracy is often an inefficient and at times a messy system. A dictatorship, on the other hand, might be quite efficient and less messy. In a dictatorship, we could simply round up all those persons we suspect to be involved in corruptions and economic crimes and simply lock them up without much ado. That is not the path Kenya has taken. It has opted for the rule of law, and the rule of law implies due process. The courts must stick to that path, even if the public may, in any particular case, want a contrary thing, and even if those who are mighty and powerful might ignore the court's decisions. Occasionally, those who have been mighty and powerful are the ones who have run to seek the protections of the courts when the circumstances have changed. The courts must continue to give justice to all and sundry, irrespective of their status or former status. What orders should we make in the motion before us? So then, my Lord, I make 3 points with regard to interest as understood by the Court of Appeal. Number 1 is that public interest means enforcement of the constitutions of Kenya. Secondly, my Lord, to make the point from what we have cited, that the first duty of ensuring that you both protect the Constitution of Kenya and you protect public interest is vested in the High Court. Every other court above the High Court, the Court of Appeal, the Supreme Court, they can only do that on the basis that they are sitting in an appeal on a decision already made by the High Court. So that, my Lord, it will be the submission that this reinforces the huge burden that this court must undertake. And, my Lord, the final issue that was being understood here is to say a constitutional democracy would not mean anything unless due process is upheld. And due process is the first duty of the High Court, to ensure that in whatever dispute that is before the court, before it is decided, the court has confirmed due process has been observed, and as a constitutional democracy, that is a standard, because they try to compare ourselves with a dictatorship, that as a constitutional democracy, we can live with the decision. As my learned colleague, Mr. Ngoya, was saying, we cannot possibly live with a decision in which we would be seeing the Chief Justice, well, if that were to be the case, you would be seeing the Chief Justice swearing on Rapo Kindiki while we are arguing this matter before the court. So that the rules are clear, the rules do not require much elaboration on what they mean. And since that criterion of public interest has been made by the Supreme Court itself, my Lord, I urge you to uphold it in the manner that will best ensure that the constitutions of Kenya and its dignity have been upheld. My Lord, there is the question, so that I believe that we are very clear on public interest, except to emphasize that for the specifics of this case, what does the call of public interest require this court to do? It's a simple call, 5 quick things. Number 1, to confirm that the law on impeachment has been properly interpreted and applied. That's the first issue. To confirm that the laws on impeachment has been properly interpreted and applied. Number 2 is to achieve substantive justice for the parties, so that when a judgment will be issued by this court, at least everybody can win something, that nobody goes home with a hollow victory. That is the whole idea of substantive justice. The third issue is to determine that the issues of the violations of the constitutions is done while the matter is still alive before the court. My Lord, very serious issues on Articles 27, 38, and 50 of the constitutions have been raised. They are all under the Bill of Rights. We urge that while public interest needs to be upheld by ensuring that when this court pronounces itself in a judgment, those issues would not have been turned into academic. Number 4, my Lord, is to ensure that the integrity of the presidential or political succession that is written in express law under our constitution is not rendered ridiculous or ineffective. And in those, I point out what we had said earlier. The desire of the makers of the Constitution was any person who will hold the office of Deputy President and therefore can potentially become President without an election ought himself to be an elected official. So that it's a big thing if this office, and without good reason, except political, an appointed person. It is in public interest that an elected deputy president, except for the clearest of evidence, except for the greatest of sins that are clear to all men of justice, is not removed from office. My Lord, the 5th issue is to do this, that this court protects the constitutions. I've already talked something about it, so I don't have to go much into it. My Lord, there are only 2 decisions, before I sit down, that I would like to point myself to. There is the issues of Githongori versus Attorney General. It is one of the cases that are before you. The facts in Githongori are notorious, and they are also notorious for the simple reason that that decision, those old advocates who are there, Kina Paul Muite and Dr. Gibson Kamau Kuria, tells us that it was largely, though it was a 3-judge bench, it was written in the style of Chief Justice Madan. My Lord, that issue said something that is important to me, the younger advocates in Kenya. And what it said is this: it emphasized the question of justice. And it emphasized the question of justice in the simplest meaning in plain English. You need to ensure everybody has a fair deal. This is to say that at the end of the day, everybody will leave the court and says, probably my advocate was not as good as I thought, but the judge did their best. But at the end of the day, let it be very clear that the court did everything that is possible to ensure that justice in its substantive form is achieved. This decision was rendered in 1984, long before the article on 159 was written, and that is why it is celebrated. And my lord, it is also celebrated, and I am mentioning here for that reason, whenever honorable men, candidates before the Judicial Service Commissions are called upon to name whose jurisprudence has affected them, it is Justice Madan that is mentioned very many times. I will strive to be like Justice Madan. And my lord, it is for good reason. All of us celebrate Justice Madan because he strived to do justice. But my lord, in the same case, the older lawyers also told us about Alan Hancock's, about Dugdale, and even about Chunga. They tell us all these stories. But my lord, in those interviews, I do not hear anybody saying I want to be like Alan Hancock's. So that, my lord, I cite Madan in order to support the proposition that Judge Madan would never remove the conservatory orders that are before you, under the principles of doing justice and offering everybody a fair and square deal. The last case that I would want to cite, before I hand over to my learned colleague, Professor Ogada, has he gone? Oh, I thought whether he has disappeared. My lord, before I hand over to my learned colleague, is to point out to one little issue.
The petitioners, you have exhausted 2.5 hours. Budget how you are going to...
Yes, sir. Yes, my lord, we are budgeting.
With the remaining,
yes,
no more than 30 minutes.
Yes,
anybody
my lord,
who wants to submit on your side,
yes, yes,
we'll
try to do
you
our best.
have no more than 30 minutes.
Thank you. We'll do our best. My lord, for purposes of this case, this is the only thing I'm citing before I go. This decision, like you've had very many other decisions on constituent power and everything, this will be an international decision. It's a decision that by universities across the country. And therefore, the least that I can do is to confirm that the lawyers for the petition are still familiarize themselves, as Macharia tried to do, with what other courts internationally have said. There is just like a small issue. On one of the most celebrated Court, Justice Brandeis says as follows. This is important. Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. End of quote. I quote the words of Justice Brandeis in order to make the point that in the matters, the proceedings before this court, we have been treated to a scenario under which an impeachment process that, if you read the constitutions clearly, is a process that ought to be a legislative one, a process conducted by the legislative organs of the Kenyan state, has been converted into an all organs of government project. With the result, my lord, that if the petitioners turns out to be right, you would then find ourselves in a situation whereby, like in BBI, this process of impeachment of the deputy president may end up being indicted as being a process that ended up being a government project contrary to what was clearly spelled out by our laws. And my lord, if it turns out that all laws were broken, and virtually out of the constitutions, I was counting them yesterday, it looks that 30 provisions of our constitutions have been seriously violated in the manner that this process has been undertaken, then we have a situations that Justice Brandeis had in mind when he talked about the government, which should be the lead in upholding the law, ends up being the principal breaker of the law, the principal violator of the constitutions. It is within your hands, your lordships and your lordships, to ensure that does not become our scenario. My lord, Macharia, my colleague, emphasized something, but I want to finish by adding something. My lord, in June 1982, when Kenya was legislated into saying that Kenya is a single-party state and KANU is the only legitimate organ, this was through a long process. Honorable Rengo, Honorable Muite, Gibson Kamau Kuria have told me the intricacies of the day, what actually. The month of October 2024, we have experienced events that the senior citizens of Kenya likened to the events of June 1982, when everything in Kenya suddenly changed. Kenya ended up to being it was a restricted democracy, but all the guardrails were removed after June 1982. Your lordships, I urge you that if these petitions, if these proceedings end up in a manner that does not uphold our constitutions, then this constitution may face the same plight that the former constitution faced after the events of June 1982. We must hold and ensure the events of October 2024 remains regrettable and an aberration on Kenya's constitutional order, not the norm. My lord, I am thankful for the time. My learned colleague, Mr. Ogada.
Thank you. How many people are yet to speak?
For these applications, there are two. I was with Mr. Ogada and Mr. Ndegwa. They have heard you when you talked about 30 minutes. They will try to divide the time amongst themselves.
My lord. Yes, my lord, I was saying that we are also interested parties in the application and we would require 15 minutes.
We will reach you. Your time has not come.
Your Lordship, the presiding judge, Your Lordship, Justice Mrima, Your Ladyship, Justice Mugambi, I will be brief. A famous quotation says that while the legislature is the will of the majority, the court must always remain the conscience of society. That is the spirit of the Constitution 2010, and that spirit has been reiterated time and again by this court. Mine is two tasks before this court today. I will be going through a panoramic vista of.
Basi mpenzi msomaji na msikilizaji, nilikuwa nimekupeleka moja kwa moja hadi katika mahakama ya Milimani pale ili tuweze kusikia ni yapi yale ambayo yamekuwa yakiendelea pale, wale ambao wanamtetea naibu rais Rigathi Gachagua ambaye amebanduliwa afisini, huku wakitaka the Court of Appeal to bar the High Court kutoka to bar the 3-judge bench from his case, kwa kwamba ni ombi ambalo alikuwa amefikisha katika mahakama pale, na pale wakiuliza kwamba waweze kufuata sheria ama katiba ya mwaka 2020. Basi tunapozidi kusonga mbele, zikiwa zimekatika dakika 55 baada ya saa 6 mchana masaa ya Afrika Mashariki, Marekani ya Kati ni saa 10:55. Tunapozidi kusonga mbele mji wa Wellington, Texas na maeneo ambayo ni karibu, niweze kuzama kidogo kisha baadaye nitarejea ili niweze kufahamisha kati ya yale ambayo yameendelea ikifika mida ya saa 7 pale, ili tuweze kuendelea na kipindi chetu cha Vijana na Maisha, jinsi ambavyo tulikuwa tunafanya pale. Alright, jinsi ambavyo tulikuwa tumefanya pale awali. Wimbo ule ambao ulikuwa unaendelea pale chini kwa chini ni wimbo Moyo Wangu ama Moyo Wacha Kiherehere cha Dhambi by Kristo Mfalme Milele Melodies International, kwa kwamba ni kwaya ambayo imeimba wimbo ule pale. Tusidi kufuatiliana kwa upamoja.
Unasikiliza AGR live abagusiglobalradio.com. Unasikiliza AGR live abagusiglobalradio.com.
Kitu masuala ambayo yanawahusisha vijana. Nikipita katika hali ile ya kuona ni nini vijana wanafanya kuweza kupata mapato yao ya kila siku.
Kwa majina anaitwa Jennifer Kemto. Mimi ni mkahaji wa hapa town.
Muuzaji mimi hapa Kisii Stadium.
Napenda kuuza laini.
Wanachimba mawe.
Pesa zilikosa, mimi nikawacha shule.
Vijana hawa wanajituma kila wakati kuweza kutafuta mkate wao wa kila siku. Wengi wao wamesoma, wako na vyeti lakini viko pale nyumbani, kazi hakuna. Sasa vijana wamegeuka kujituma angalau kupata mkate wa kila siku. Basi tutakuwa tunaangazia ni yapi yale ambayo vijana hawa wanayapitia wanapoendelea kutengeneza ama kutafuta mkate wao wa kila siku minajili ya kuweza kulisha familia za kwao kila wakati wanapohitaji. Ungana nasi kila siku tutakapokuwa tukikuletea kipindi hiki Vijana na Maisha, tuone ni jinsi gani wanachituma wao wenyewe kuweza kupata chajio ama kila mkate wa kila siku.
Ungana nami Geoffrey Nyakundi kwenye Abaguzi Global Radio AGR News, tuzemezane moja kwa moja.
Hadi wakati mwingine wa Vijana na Maisha. Kwa heri kwa leo ninapomalizia kula.
Texas USA goika astensingima. Abaguzi Global Radio nere tunkwarte asebtunwane chingongo chonsi cheliro balya gusine chinsemo chire ao.
Nchenguru kwa pita nyasani nyamwaru kurumatongo gontegerete Abaguzi Global Radio.
Jeni ngongoro ku angwenyi Danieli rwaiga chiro ya usongo kwa nyamagena ni gontegerete Abaguzi Global Radio.
Asamaleta ngogwedi na kwambuka muko koroya secho ya busongo kole biashara ni gontegete Abaguzi Global Radio.
Samaleta ngorofani iskerbongo kole biashara busongo Abaguzi bategerete Radio Global Radio.
Bono nabakotonyora ase website yaito ya www.abaguziglobalradio.com. Oboigo nabakotonyora ase YouTube channel yaito o like na subscribe goetera www.abaguziglobalradio.com. Elionyore merobiri yaito eye mase yemo ase simyao yakoboko. Abaguzi Global Radio ekenakio ekeumbu kyomuzi.
Basi mpenzi mtazamaji na msikilizaji, zimekatika dakika 2 baada ya saa 7 mchana masaa ya Afrika Mashariki, Marekani ya Kati ni saa 11 na dakika 2. Rais William Samoei Ruto ametoa ahadi kwamba serikali itahakikisha kwamba kufikia mwaka 2030 watoto wote hapa nchini Kenya watakuwa wanapata afya nzuri na pia chakula kizuri tu, chakula pale shuleni. Ameyazungumza hayo na akisema kwamba serikali itakuwa inaongeza bajeti yake haswa kwa pesa zile ambazo zinatumwa katika mashule kuhakikisha kwamba watoto wanapata chakula cha mchana na pia wanaendelezwa kukula vizuri na kupata madawa iwapo kutakuwa na hitaji la kufanya vile. Alikuwa anazungumza katika mkutano katika ikulu ya rais pale wakati ambapo walikuwa wanahusika katika wale ambao ama yale mashirika ambayo yamewekeza kuhakikisha kwamba mtoto anapata chakula akiwa shuleni. Na tukisonga mbele ni kwamba spika wa bunge la kitaifa Bwana Moses Masika Wetangula amewashtumu baadhi ya wabunge wale ambao kidogo huonekana wanazungumza kuwili haswa wakati wapo katika ama wamo na watu ambao waliwapigia kura kutoka maeneo bunge yao na kile ambacho huwa wanakifanya katika jumba lile la bunge la kitaifa. Wetangula alikuwa anasema yale kwamba wabunge kuna wale wabunge ambao wamo bungeni na hawajaifungua mdomo kuzungumza hata kitu moja tu, huku akiwakukumbusha kwamba yale ambao walikuwa wameahidi walikuwa wameahidi wananchi wananchi watakuwa wanayatilia maanani na pia kuchipuka na kutaka action kulingana na yale ambayo hatakuwa wameyasema pale. Kwingineko, seneta wa kaunti ya Narok Bwana Ledama Olekina ameweza kutoa ahadi ama ameweza kupropose kwamba wabunge ambao wameteuliwa kutoka maeneo bunge tofauti kuserve kama cabinet ama to serve the cabinet from the parliament wanafaa kupewa nafasi ya kuendeleza uongozi kutoka maeneo bunge yao ikiwa bado uchaguzi hujafanyika kutoka maeneo yale ya bunge lao pale. Na kwingineko, kesi yake naibu rais Rigathi Gachagua ambaye alibanduliwa mamlakani ingali inaendelea katika mahakama kuu pale. Kumbuke kwamba kesi hiyo ambayo inasidi kufuatiliwa pale na kuendelea ni pale naibu rais Rigathi Gachagua alifikisha appeal katika mahakama ya appeal pale huku akitaka kesi ile ama ile panel ya majaji watatu ama the 3 judge bench iweze kutupiliwa mbali na kuchitoa katika kesi ile ambayo inamkabili. Hayo na mengine mengi mpenzi mtazamaji, tutazidi kuyafuatilia kwa karibu ili tuweze kufahamisha kwa kina yale ambayo yanaendelea. Jina langu ni Geoffrey Nyakundi Morara aka Jeff the Presenter. Tunafazidi kusonga mbele ndio kufuatilia kipindi chetu Vijana na Maisha. Nitazama kidogo, nikirejea nitapitia jumbe za wale ambao wametuma pale, kisha kipindi kinaendelea jinsi ambavyo kimepangiwa.
Unasikiliza AGR Live abagusiglobalradio.com.
Wimbo ule ambao tulikuwa tunaupata pale ni wimbo Zitakuwa Nyota Tajini, wimbo ambao umeimbwa na kwaya ile ya Rale SDA kwaya, wimbo ambao utakuwa unatufusha katika segment nyingine na ya mwisho kabisa katika kipindi chetu cha Vijana na Maisha.
Nzuri ninayotaka kuiona, nisimamapo karibu na Mwokozi, tajini zitakuwa nyota. Sijui tajini mwangu kama nyota zitang'aa kila wakati nitakapoamka katika majumba, zitakuwa nyota tajini.
Unasikiliza AGR Live abagusiglobalradio.com.
Kwa nguvu za Bwana nitafanya kazi, nitavuta roho za watu, ili niwe na nyota katika taji Bwana